Canada tonight. Ottawa has made major changes to Canada's Divorce Act. It now sets out a specific list of factors that the courts must consider when weighing the best interests of a child. That includes family violence, which was noticeably absent from the Act for years. The definition goes beyond physical violence. It also includes sexual, psychological, and financial abuse. The federal government says these are the first substantive changes in family law in decades. For more, I'm joined now by Angela Marie McDougall. She's the Executive Director of Battered Women's Support Services in Vancouver, and David Morneau, the Executive Director of Child Witness Centre from Waterloo. Thank you both for taking the time to be here on Canada Tonight. Angela, I'll start with you. We just heard 20 years since we've seen changes to the Divorce Act. And actually, when I tweeted that we were going to be talking about this, someone said that's not already in the wording of the Act. They were surprised. Right. So in your eyes, is this long overdue?
Most definitely. It's long overdue. And it's on the heels of some similar changes that we saw here in British Columbia, where the Family Law Act in BC was changed in 2013 that included some of the similar language that we're seeing today with the Divorce Act here in Canada. So we've had some experience with this act and with this language here in British Columbia, which makes me very thoughtful in a sense of how Canada will do in deploying what I think is actually some very progressive ideas in law.
David, you were a family lawyer for many years before you moved into youth advocacy. Talk to me a little bit about how not having this language in the Divorce Act came into play in family courts.
Well, typically, Ginella, when it came to conduct, the Divorce Act had said that no conduct was to be taken into account unless it affected somebody's ability to parent. Now, you can imagine that domestic violence, intimate partner violence, family violence on the whole would have an impact. So it's not like the courts didn't give regard to it, but it always caused me to scratch my head. Why is this not defined? We had reports done. We had data and information that suggested to us that this is something that is insidious. And I think where the legislation goes in not just, you could have asked any family lawyer or many family lawyers whether they had dealt with domestic violence before. And oftentimes what you'd hear is, oh, no, I talked to them and there was no physical violence. There was that automatic equation of any violence or domestic violence to only be physical violence. This goes further. It recognizes, and the coercive and controlling behavior is so significant in the advances that are being made in this legislation. It's definitely long overdue, but it's something that's welcome, and it's, quite frankly, it's a start. We start with a definition. I think where the rubber is going to hit the road is how that rolls out, what the professionals working within the system are going to do. Like, how are they going to be trained?
Yeah, Angela, I want to get your take on this as well. What had you seen dealing with women who were coming out of domestic abuse situations, who were going through the court systems, and did you see this gap with the Divorce Act not outlining this?
Well, for sure. I mean, the gap is there most definitely, but beyond that, we have to really take into consideration here, and David's point is well taken. And that it's well beyond, I think, what we're seeing in British Columbia right now is that we're having a significant problem, even though we have, I think, some very progressive language in the Family Law Act here in British Columbia. What we're not seeing, actually, is a lot of changes in how the folks within the legal system are responding. And we're seeing some of the same well-worn problems being deployed that are inhibiting, in particular, women that experience domestic violence, intimate partner violence, sexualized violence within an intimate relationship. So, and this is actually even with some training and with some screening for lawyers and a little bit of support within the apparatus. And so this continues to be a problem. And so I'm not sure if we're going to see, I feel somewhat cynical in a sense because of doing this work for a long time. Again, and what we're seeing here in British Columbia, and thinking about how Canada is going to roll this out within the domestic, for domestic violence survivors that seek divorce.
Right. So the language, adding the language is one thing, but actually seeing it into practice is another. And David, I want to ask you about that. You know, we see that they're including within the wording of family violence, sexual abuse, harassment or stalking, psychological abuse, and financial abuse, all under the definition of family violence. The question becomes, do you have to prove it? How do you prove it? Can you talk to me a little bit about how you see this sort of playing out, and do you have concerns about that?
Well, I think this is, when it comes to the standard of proof in any civil court, you're talking a balance of probabilities, as opposed to criminal court, which is beyond a reasonable doubt. So really, if you look at it from a tipping of the scales, or 51% to 49%, that is a level of proof that's expected. But I almost look at it from the standpoint of, how are we going to improve? Really, the system has failed to address how we can make families' lives better. Fighting it out in an adversarial, antiquated, anachronistic system, quite frankly, I'm surprised there are not more fatalities coming out of the court, because you put them into a powder keg to fight it out. And I'm sure Angela can tell you horror stories. I know that when I practiced, there were horror stories. The system is still set up, and this is where I think Angela's cynicism is a point well taken, in that, how are we going to improve this? What systems are we going to put in place? What professionals? How about we augment our systems by having professionals like Angela, or people with the expertise? I mean, I certainly, in my last 5-6 years of practice, I stepped away. I did mediation and collaborative law. That allowed me to create systems that could be controlled. That created systems where, for example, people who had experienced domestic violence, you could set the system up. It didn't mean them sitting in a court or sitting in a room, one against the other, and feeling polarized, which is what the court system really does. So there's more to be done. This is a great start, and we're recognizing it. But I think there needs to be training of the professionals. We need to start augmenting our systems with professionals with the expertise. We need to recognize that the law is not static. It needs to be evolving, growing, and breathing. And we need to look at it with the data collected, like what Angela's talking about, 2013, and yet what improvements are being made. So let's reflect on it every 3, 4, 5 years.
Angela, we heard David there just mention the horror stories, fatalities.
Right.
We know that includes ex-partners and children as well. How do you see this law impacting children in particular? And maybe the question also, what more can be done to ensure that children are protected through this system?
Yeah, so when there is domestic violence, we're talking about power and control. And one of the most extreme expressions of power and control is lethal violence. And for victims of domestic violence, intimate partner violence, we know that they are most at risk of lethal violence within the first 12 months. And so the legal system has sometimes not been effective in providing a measure of safety in that case. And David's point about the definition of family violence, the inclusion of coercive control, is actually, I think, very, very progressive language, and in so many ways is an advancement to what we have in British Columbia in really understanding the dynamics of family violence, and within that, naming fairly clearly that children that are witness or that are experience that directly or indirectly is I think a really vital piece of acknowledgement of the impact on children.
David,
there is a lot still to unpack here in terms of how we will deploy this, and let's also note that I think marriage is becoming a bit of an antiquated kind of piece, and that I know for us, most of the folks that we deal with aren't married and that are living within common law relationships, and that's a piece also I think we should recognize in the change in the culture.
David, I just want to extend the question about children to you as well, because you now work with children as the executive director of Child Witness Center. What is the impact of these laws on children when it comes to divorce, and how do you hope that it can be changed for the better?
Well, my role right now, the children that we work with are children who are victims within the criminal justice system, and oftentimes there's an intersection between the family system and the criminal system. What is promising to me, for example, is the recognition that it's not just the direct impact on the kids, more often than not. And I was an advocate for children for 15 years in Ontario before I stepped over to take this role. And one of the things that I noticed, it's the indirect. It's how the violence impacts the other parent's ability to parent themselves because they're living in fear. And the child seeing that fear, and that fear being then visited on the child, although they've never necessarily observed an act. They don't necessarily know what's going on, but it's impacting that parent's ability to do that. And there is some recognition in this legislation for that as well. And, you know, I think this is a good starting point, but very much to Angela's point, if we're going to tuck this away for 20 more years and say, you know what, hey guys, we got it right, we're doing well, and walk away from it and not revisit it for 20 years, we will have the same problems over and over again. This needs to be living, this needs to be breathing, we need to visit it, revisit it frequently and periodically. So.
All right. David Marneau in Waterloo and Angela Marie McDougall in Vancouver. Thank you both so much for your time.
Thank you very much, Ginella.